Welcome to Trademark Law Radio, a top web resource on issues of trademark infringement, trademark licensing, trademark protection, and trademark registration.
Welcome to Trademark Law Radio. My name is trademark attorney Enrico Schaefer, and today we're going to be talking about name and brand protection. Look at, if you're going to start a new company, if you're going to launch a new product, if you're going to launch a new service, if you have a new slogan, if you have a new logo, you're going to need to protect that. And by protect the logo, the name, the mark, what I mean is you want to be the only one in the world that can use that brand that you have picked for your company or product or service. You want to be the only one in the world that gets to use that for your goods and services. So if you're a faucet company and you're manufacturing kitchen sinks and the things, you want to be the only one who gets to be Delta Faucets. If you're an airline, you want to be the only one that gets to be Delta Airline. Now, Delta Faucets and Delta Airline can coexist in the trademark world because no one's likely to be confused about who is who. In terms of name and brand protection, there's two levels of protection. One, there's common law protection. Two, there's trademark registration, which gets you some super protection. There's two different types of marks that you can protect. There's a trademark, and a trademark is for goods, products, tangible things that you can sell. Okay, and this is what we normally think of when we talk about brand protection is trademarks, but you should know if you happen to sell services, then you actually would be getting a service mark as opposed to a trademark. So if you're a consultant or an accountant or a lawyer or a doctor, or you sell your own intellectual property, your own ideas, your own assistance and help in the service market, then you're going to be a service mark. Now, what you want to do is make sure that you tell the world that you are claiming exclusive use over this particular mark, whether it's a trademark or service mark. So if it's a good, a product, you're going to use the TM for trademark, and you're going to add that to the right and top of your word or symbol or logo. So in the case of Microsoft, you would add a TM to the right of Microsoft. Okay, that would tell the world that, hey, I'm Microsoft and I'm claiming trademark rights in this word, in this design, in these colors, in this logo, etc. So TM designates trademark, and it designates essentially a common law trademark, meaning you haven't achieved the circle R yet. You're not registered, but you still are claiming trademark rights. Okay, the goal is to get registered, is to be able to get that circle R, but you got to get through the trademark registration process with the USPTO or a foreign trademark service in order to get there. So always add the TM to your trademark while you're going through the registration process. And even if you're not going to get registered, you should add a TM for your trademark in order to tell the world you're claiming exclusive rights to this word. If you happen to be a service company, like let's say Quicken is offering consulting services for loans, or they're offering loan service, then they would use an SM for service mark, telling the world that we claim exclusive rights over this mark and we provide services. So Quicken would use the SM. Now, obviously, both of these companies, all three of these companies, Microsoft, Intel, and Quicken, have a registered trademark, so they would go directly to the circle R to tell people that we have a registered trademark, and they would put that circle R right where the TM is or the SM is in each of these instances. So that's what you need to be thinking about in terms of telling the world and providing notice to the world that you're claiming trademark rights. Understand that if you get registered, if you get to that circle R point, you get a number of tremendous benefits that provide you the leverage you're going to need in order to protect your trademark. So that really is the holy grail of name and brand protection, is to get the circle R, get registered. It takes about 12 months. A good trademark attorney can get your trademark through the trademark registration process in about 12 months, and you can then start using the circle R after registration next to your trademark, telling the world, I claim exclusive rights, and in fact, I am registered. I'm a registered trademark. So Let's talk a little bit about some of the benefits you get if you're registered. You get a presumption of validity that people can't necessarily attack your trademark. Get a presumption that you're first. You get super rights for anyone who engages in intentional infringement. So you definitely get a lot of benefits. If you're going to have to send someone a trademark infringement threat letters, you want to be registered. Okay, before you file, you need to understand that before you file for trademark registration, you already have common law rights. And forgive the pen here, it's a little tough sometimes to make this work just right. But you're going to have common law rights in order to get yourself through the registration process. Now, common law trademark rights allow you to claim first use, allow you to send a trademark infringement threat letter. If you put the TM in there, you're providing notice. All that is good. But understand, before you file, you still have trademark rights. Okay, and in the United States, under the USPTO law, it's still the first person to use the mark in commerce is the one that's going to have the first common law trademark rights. Okay. Now, let's talk about picking a name. Always an extremely challenging thing because you got to pick a name for your brand, pick a name for your company. So go to your partners, start brainstorming. Try and think of things that are non-obvious. An arbitrary or suggestive trademark is much better than a descriptive one. Everyone always wants to name their company after what they do. Jones Consulting Service, car parts. Those are terrible trademarks. You want something that's arbitrary that can only mean you. Okay, find at least 3 names that you can all agree on that sound like they'd be a good brand. Is it pronounceable? Is it something that people will remember? Is it easy to spell? Because then after you pick your 3 names, you're going to have to go back to your trademark attorney, and you are going to have them do a trademark clearance for those 3 names to see which, if any of them, is available in the market in your goods and services. So it could be that someone else is already out there using something similar, and let's talk about that. Trademarks are not literal. That is to say that just because you pick a trademark and no one else is using that exact trademark does not mean that there's not a trademark infringement problem. If you were to pick Apple fences for your trademark, right? Chances are you could do that even though there's an Apple computer, because no one's going to think that Apple computer is selling fences. So there's no likelihood of confusion. So if you were to pick Apple, you would say, well, I looked at Apple fence and I didn't see any other companies that are named Apple selling fences. But the trademark office, the examining attorney, he's going to look at all kinds of variations of the word Apple. He's going to do A-P-L-E, A-P-E-L, and all kinds of A-P-P-A-L, all kinds of variations, because anything that is phonetically similar, anything that sounds like it might be the same, also means that it might potentially infringe. Okay, so a good trademark registration attorney will know how to conduct a trademark clearance search in order to tell you what the risk is if you should pick that trademark for a brand. Okay, you do not want to pick a word or a symbol or design and find out 3 years later that someone else has prior use rights, prior trademark rights in that word, and now you have to rebrand. You lose your entire investment in your brand, and the cost of repackaging and rebranding is incredible. Okay, so the USPTO.gov is the website where you can learn a lot about trademark law. It's certainly going to have a lot of guidelines. There are online forms. One of the questions we always get is, well, do I need a trademark registration attorney in order to file my name? And the answer is no, technically you don't, but it sure is a good idea because there's a lot of fields that have to be filled out. There's a lot of things that have to happen. For instance, your trademark clearance, that none of that happens at the USPTO level. If you don't do a trademark clearance before registering, you could have a problem. My name is Trademark Attorney Enrico Schaefer. That's all for today on Trademark Law Radio.
You've been listening to Trademark Law Radio. Whether you are facing a trademark infringement, licensing, monitoring, or trademark registration issue, we have a trademark attorney ready to answer your questions.